All right, everyone. Thank you so much. So, welcome to today's webinar on H-1B compliance. My name is Kalika Sharma, and I will be your host and moderator for today. We really appreciate you taking the time to join us. So, as you know, that today's session, we will explore some complexities around the H-1B compliance around these challenging times. So few administrative items. So if you have any questions along the discussion, please feel free to put it in our Q&A button that you can see on the screen. It's at the bottom of your screen. You can post it there, and we will take your questions in the end. We are also recording this session, and this session will be made available as per the request. So let's just dive right in. So before we begin around the actual session, I want to talk a little bit about what is our firm, the VKM Law Group. We have over 30 decades of combined experience in the employment-based immigration. VKM Law Group offers the customized client-centric legal solution to meet your business needs. And our speaker today, Vinay Malik, who's going to talk a lot about the compliance issues and how we can navigate through it. He's our principal attorney in the VKM Law Group. He has over 24 years of experience in the both legal and engineering field. So his technical expertise combined with his legal acumen makes him the exceptionally qualified to address today's topic. So without further ado, we will show you what's today's agenda. Today, we will overview the current economic pressure which are impacting the H-1B employers. What are the key compliance considerations and the practical guidance for businesses navigating these requirements? So I'm very pleased to hand it over to Vinay, and Vinay, you can take it from here.
Thank you, Kalika. Really appreciate the kind introduction. In addition to everything Kalika mentioned, we will also just touch upon how we think the Trump administration is going to impact the H-1B program. I've had the experience of preparing and filing H-1B visas, that is my law firm, during the previous Trump administration. So we have a good sense of what lies down the road come January 20th, 2025. So let's get started. Next. So why is H-1B compliance crucial now? We are all quite aware of the economic pressures on H-1B employers. They're not immune to the current economic climate and the, frankly speaking, very bleak job prospects and so on and so forth. As you know, the layoffs are at an all-time high. A lot of companies are not hiring. Their budget cuts, ChatGPT and other AI tools have rendered some positions obsolete. A number of tech positions, especially, are being outsourced to low-cost destinations such as Argentina and India. In fact, I recently heard Google shut down their Python programming department and outsource the entire department overseas. So there's a lot of pressure on employers, and really the H-1B visa program is not immune to these external pressures. Next. So what are the key compliance components for just the H-1B visa? Now, you may have heard of some of these terms, and you may not. So just for the benefit of people who are not familiar with these terms, I'll just define them. The public access file is a key compliance component for an H-1B visa. Every time an LCA is filed, the employer needs to create a public access file. And the public access file is really a file that includes certain documentation which should be made accessible to anyone in the public should they come and ask for it. Now, 9.9 times out of 10, no one off the street is going to come and ask for the public access file. Typically, it is a Department of Labor or a USCIS site visit, which is where these documents are asked for. Another key consideration is when do you file H-1B amendments? There was this case from a few years ago, matter of Simeo, which provided one scenario where an H-1B amendment had to be filed, but there are various other scenarios where H-1B amendments should be filed in a timely manner. And there are some scenarios where you really do not need to file an H-1B amendment. So we'll get into that a little bit. A really key topic to discuss, given today's economic environment, is benching. What is benching? And how does it implicate H-1B employers? And what are some of the ramifications of benching H-1B employees? Another key component is termination. Now, a lot of HR professionals know what termination means. How do you terminate an employer? But when it comes to an H1, terminate an employee, but when it comes to an H1B employee, there are certain additional steps that need to be taken in a timely manner to effectuate a bona fide termination of an H1B employee, failing which the employer can be subject to back pay, interest, and penalties. Next. So let's get into what a public access file is. Again, as I said earlier, a public access file is a collection of documents pertaining to each H-1B visa petition that needs to be maintained for a certain period of time and has to be made accessible to any member of the public, including the agencies, when such information is requested. There are certain legal requirements for maintaining these files, and if these requirements are not met, the H-1B employer can be subject to significant fines and penalties. Next. So, what is the required documentation for a public access file? The day you file an LCA, which is Form ETA 9035, you have 1 day from that day to create the public access file as an employer. And typically, this is something the HR department of the employer handles. So what goes into the public access file? A copy of the initiated LCA. The LCA should include the initial wage rate, the actual wage pay memorandum, meaning some documentation that the HR department of a company keeps as to how they calculate the wages that need to be paid to really all employees. A copy of the prevailing wage documentation. This could typically be some database or a wage survey that the employer used to determine the appropriate wage to be paid to the H-1B employee. Documentation about the benefits that are offered to all workers, including the H-1B workers, in addition to the salary. Now, one key component to keep in mind is that an H-1B employer cannot offer benefits to an H-1B employee that are less than the US workers. So the benefits and salaries have to be consistent across all employees, be it someone on H-1B or a US worker. We also need copies of documents which prove that the H-1B employee was provided a copy of the LCA. So something like a confirmation letter signed by the employee saying, yes, I did receive a copy of the LCA. Next. In addition, now this is really important, the day you file the LCA, ideally on that same day or within 1 day, the H-1B employer needs to post a copy of the LCA at the location where the employee will work, and it needs to happen at 2 conspicuous locations in that office. All right, so in case of a third-party placement, if an engineer is not working in the employer's office, but is working at the location of an end client, the LCA has to be posted at 2 conspicuous locations on the premises of the end client. right? And we need confirmation of that. So whoever posted that notice needs to sign a confirmation letter saying, yes, this notice was posted at 2 conspicuous locations. And it has to be posted for 10 consecutive days. Now, these days, people really don't, especially IT companies and finance companies, don't post a lot of notices physically. If they use an electronic posting room as a matter of due course, that will suffice as well. But the point is that the notice has to be posted for 10 consecutive days. All right. The rest of the points on this slide deal with more specific situations, such as corporate restructuring, determining, which employees are exempt, and if some employers are subject to additional attestations because they are willful violators of the H-1B program, or if they're H-1B dependent, then they are subject to certain more attestations, such as they need to, for example, document the actual recruitment methods that were used to try and recruit US workers and H-1B employees. So if an employer is subject to those additional attestations, that documentation also has to be included in the public access file. All right. Now, just to digress a little bit, for those who don't know, an H-1B dependent employer is someone that is subject to certain definitions, right? So how do you calculate H-1B dependency? If an employer has 25 or fewer full-time employees in the US, and if at least 8 of those employees are on H-1B status, that employer is considered to be an H-1B dependent employer. If the employer has between 26 and 50 full-time employees in the US, and at least 13 of those employees are on H-1B status, that employer is also considered to be an H-1B dependent employer. If an employer has 51 or more employees, again, full-time employees in the US, and at least 15% of the US workforce, if they are on H-1B visas, that employer is also considered to be an H-1B dependent employer. Now, a quick tip, every time you file an LCA, before you actually file it and during the preparation of the LCA, it is not a bad idea to conduct a quick test to see whether you are H-1B dependent or not, right? So it's a good idea to keep track of the total number of US employees on your payroll and also how many of them are on H-1B. You should at least have a rough idea of that every time you prepare and file an LCA. Next. So timing is really important. When do you create the public access file? As I said earlier, within 1 day of filing the LCA. Now, when you file the LCA, it doesn't get certified for at least 5 to 7 business days. But you have to, so what do you do, right? You've already created your file, you've put in the initiated LCA. Well, when the LCA is certified, ideally you should replace the initiated LCA with the certified LCA in the public access file. So again, the HR person has to keep track of all of this, right? How long do you retain the public access file? You need to retain it for at least 1 year beyond the last date on which the H-1B worker was employed by the organization. So, for example, if you have an employee who worked on H-1B status until the 25th of March 2024, you have to maintain his or her H-1B public access file until at least March 24th, 2025. So that's 1 year. Another tip for this whole public access file situation is you really should be reviewing these files periodically to make sure that they are current. So for example, I get hired as a software developer and I'm being paid $100,000, right? But then I got a huge promotion and I'm now a computer architect, right? And so an amendment had to be filed, and we'll get into when an amendment needs to file. In that case, the public access file needs to be up. My public access file needs to be updated with the new LCA that was filed and the new wage data, so on and so forth, right? So again, it's a good practice to review these files at least on a quarterly basis. Next. Another key issue in H-1B compliance is amendments. And this is going to be particularly relevant with the new administration, and I'll get into that shortly. When do you file an H-1B amendment? Now, a lot of people are under the impression, well, if the work location changes where it's more than 50 miles away from the certified LCA work location, we should file an amendment. And that comes from matter of Simeo, which was an administrative appeals office decision. Well, that's only one particular situation in which you should file an amendment. The rules say that every time there's a material change in the H-1B employee's position, that material change necessitates the filing of an amendment. So what are some other material changes besides the work location being more than 50 miles away than the previously certified location? A change in occupation. I started off as a business analyst and an LCA was certified under the computer system analyst SOC category. And now I have graduated into being a software developer. So the occupation code changed, the SOC code changed. Is that a material change? It is. And you really should file an amendment, even if the job location did not change. Now, another material change could be I got hired at $100,000, and for whatever reason, I did really well and I got a double promotion. Lucky me. And now my salary is $160,000, a $60,000 increase. That's a pretty significant increase, right? That could constitute a material change. Well, something more relevant to the current economic situation is I got hired at 150, but due to the economic situation, my salary has to be reduced. And if I was at a level 3 salary, it's now come down to a level 2 salary. So I think there is a change it's a significant change. So that again can constitute a material change, and it may necessitate the filing of an H-1B amendment. Next. So again, we talked about some of these changes or material changes that require filing an amendment. What's the timing of filing an amendment? When do you file the amendment? Ideally, you file the amendment before the change takes effect. So, for example, if I am working in Princeton, New Jersey, and my work location has changed to Boston, Massachusetts, and I'm moving to Boston on December 1st, the amendment should ideally be filed before December 1st, meaning the receipt date of the amendment should be before December 1st. Does the amendment have to be approved before I can move to Boston? No, it just has to be filed before I get to Boston. All right. Now, here's another, there's some common misconceptions about the H-1B amendments that I'd like to talk about. I work at Carnegie Center. That was the location that was certified for the LCA. But now I have also decided to work from home in Princeton, which is not very far from Carnegie Center. Do I need to file an amendment? The answer is no, because it's within the same MSA. And also assuming there are no changes in the job duties, my salary is the same. We don't need to file an amendment. However, the LCA that was certified for Carnegie Center, the same LCA now has to be posted in my home at 2 conspicuous locations. And the posting of this LCA has to be documented and placed in the public access file. So that's, again, something that's very important. There's also the short-term placement rule, which says that if an H-1B employee is working at some other location, which is not on the certified LCA, and that's perhaps more than 50 miles away from the certified location, that employee can continue working there for up to 30 days, consecutive or non-consecutive, in a year, right? So you have, like, I call it a grace period, right? So that's where, you don't file the LCA because the amendment because, well, I'm not sure if I'm actually going to be there for a long time. I'm just going there to gather requirements or something like that. But again, you have a limit of 30 days in a year. Now, that limit can be extended to 60 days in a year, but then the additional requirement is that you have to show that that employee still has ties to the originally certified location, like he or she lives close to the originally certified location, he has a workspace at that location, so on and so forth. Next. All right. Now we get on to a very important topic. This topic deals with benching. What is benching? What does it mean? Right? A lot of people have heard about this term benching. At a high level, it means that a person is on bench. Well, what does that mean? Well, it means a person isn't working. But in the H-1B context, right, benching takes on a whole new meaning. The reason being, when you file the H-1B petition as an employer, you're attesting to the fact that you will pay the H-1B employee the LCA wage at a minimum, right? So there are very few exceptions to that, and we're going to get into that in the next slide. So again, what is benching? Benching refers to workers who are in non-productive status due to a decision made by the employer. So I'm an H-1B employee. I'm ready to work. I'm showing up to work every day. You, the employer, say, Vinay, you cannot work. Now, why would that be? Hey, we have no work for you. Times are tough. The client contract ended. It did not get renewed. Or Vinay, for whatever reason, your law license has expired and you really can't work until it gets renewed. So I say, well, I'm here. I'm ready to work, but I don't have my law license. It's still being processed. So I really can't bill. I can't do any billable work. And the employer might say, well, then in that case, I don't want to pay you because you cannot bill for your time. Too bad. If I'm an H-1B employee, I still have to be paid the LCA wage, irrespective of the fact that my employer does not have any work for me, right? So again, we talk about non-productive status is something I just explained. And this is a pretty strict rule. And there have been a lot of cases, especially in the last few months or maybe year, dealing with benching issues because as you all know, times are tough, and especially in consulting firms, if there is no client contracts, you don't have any money coming in, you have no money coming in, how do you pay your H-1B employee, right? And if you don't pay the H-1B employee, that employee is technically out of status because in order to stay on H-1B status, you have to be paid your um, LCA wage. So it's again very, very important that employers, H-1B employers, take note of this fact, right? Next, please. All right, H-1B employee termination and compliance requirements. Now, again, in the current economic climate, H-1B compliance terminations have taken on a whole new meaning because a lot of employees are being laid off or they're being placed on bench. And while it at a high level in the general HR world, a termination is effective when you expressly let the employee know that their services are no longer required, and that's the end of it. Not so in the H-1B employee context. If you want to terminate an H-1B employee, you have to follow some very, very specific steps, all right, to ensure that the termination is bona fide, absent which you could be held liable for all the wages that the H-1B employee was owed, plus interest, plus penalties, right? And so that can really add up. And there have been numerous cases in the past few months with respect to this, especially in the consulting world where things get a little nebulous. And I'll talk about a case that happened a couple of months ago in New York and how the decision went in the favor of the employee as opposed to the employer. Next. So, what constitutes as employee termination? To ensure a bona fide H-1B employee termination, three things need to occur, and they all need to occur in a timely manner. Express termination of the employee. So what do you mean by express? It needs to be explicit. There cannot be any ambiguity. So, hey, Vinay, we have no work for you. Does that mean I'm terminated? Probably not, right? Hey, Vinay, times are tough. Does that mean I'm terminated? No. Vinay, your services are no longer required effective December 1st, 2024. Your last day at work will be November 30th, 2024. That's an express termination. And again, as you can all imagine, it's better to do it in writing. And specifically, it should be acknowledged by the employee. So you can send an email to the employee and ask the employee to acknowledge receipt. Sometimes that does not happen. You can send a letter, right? Certified mail, return receipt to the employee's last known address. A lot of courts have considered that to be an express termination because you sent a letter, it was received, and you sent it to the last known address. Now, sometimes the employee may not be there. In this case, you have to document steps taken to expressly notify the employee that they have been terminated. So what are those steps? An email to perhaps the person's personal email address, right? You could probably put read acknowledgement. I think that's an option on the email, right? Where you say, please send me a notification that the recipient has read the email, right? So you do that. You make a phone call, leave a message, send a text message, right? Send a letter. So again, you got to make sure that you have sent a written communication and that the employee is aware of the termination. So that is what express means. The second important step is you have to notify USCIS of the termination, right? So mere express termination of the employee's service is not enough. You do that, the next thing you do, or simultaneously, ideally, is you send a letter to the USCIS service center that approved the H-1B petition, withdrawing the H-1B petition. Now, under USCIS policy, the day USCIS receives the letter is the day they consider the employee to be terminated. Now, many a times you won't get a written acknowledgement from USCIS for months after you send such a letter. It is therefore good practice that you send this letter via a trackable service such as FedEx, UPS, or USPS Express Mail. Because in that way, you can show to a court, listen, USCIS received the letter on Jan 5th. Sure, they did not send me the acknowledgement until April 10th, but they did receive the letter on Jan 5th. So the termination is effective Jan 5th, right? The third thing, you have to offer return transportation to the employee to his or her home country. Does not have to be business class, does not have to be for his or her family, just the employee. You don't owe his or her family anything, but you have to offer the return transportation to the employee. Many a times the employees do not choose to go back to their home country, and they may choose to transfer the H-1B to another employer. Courts have held that in such a situation, the filing of an LCA by the other employer relieves the current H-1B employer of the obligation to pay the employee the return transportation to their home. Why? Because by filing of that LCA, the employee has shown his or her intention to stay in the United States and not go back, right? But absent such a circumstance, it is always in the best interest of the H-1B employer to offer the return transportation to the H-1B employee. So again, these 3 steps have to be taken. What I also recommend to some of my, to actually all my employers, and this is not absolutely necessary because when you withdraw the H-1B petition, the underlying LCA is also effectively withdrawn, but it does not hurt to actually go and withdraw the LCA in the flag system of DOL. Now, what happens if these 3 steps do not occur? So this is where we had a case in New York. It was a consulting firm, ironically providing consulting services to New York State. And what happened in this case was the employer supposedly terminated the services of the employee, but retained all their information in their database and kept sending them third-party placement opportunities, right? And so that kind of confused the whole situation, right? And so the administrative law judge said, wait a minute, you said you terminated him, but you were still in touch with him. You were still sending him job offers. I really don't think you expressly terminated him. So you have to be very careful when you do this because you have to let the employee know, look, you are no longer on a payroll. We've terminated your services. However, we are willing to rehire you if you're willing to work on this contract, right? So this has to be very explicit and you cannot leave any room for ambiguity. And that did not happen. The second thing that did not happen was that the employer did not notify USCIS of the termination. So the judge said, look, irrespective of whether you expressly terminated the employee or not, you did not notify USCIS. So that was not a bona fide termination. Therefore, you, Mr. Employer, are now liable for back wages all the way back to from the time you stop paying the employee, right? And that was a lot of money. Plus, you got to pay interest and penalties to the employee. And in this job market, a lot of the employees don't find another job. So they're more than happy to take your money. So this is something you really have to keep in mind. So again, so those are the risks of improper termination. Next. Now, this is a bonus. We recently had the elections and we have a new president coming in next year. Now, as I said, we've had the experience of filing and prosecuting H-1B petitions in the previous Trump administration. And we kind of have a sense of what lies in store forward. So I'd like to touch on a few points that I think might be relevant, especially under the current administration, and how I think it will impact the H-1B visa program. So we expect the new administration to redefine what a specialty occupation is. But what I mean by that is I think they're going to narrow the positions which qualify for the H-1B program. Some of you old timers like me might remember there was a memo which said that computer programmers, not software developers, but programmers, were not eligible for the H-1B visa, right? So we expect more memos like this coming out under the new administration where they specifically target certain occupations and try and make them not H-1B eligible. We also expect a redefinition of what constitutes an employer-employee relationship, notwithstanding the IT serve settlement. This might happen through the regulatory route, where USCIS will likely come up with new regulations, again, narrowing the definition of what constitutes who is an employer and who is an employee, specifically in the H-1B visa context. And we think this might impact consulting firms disproportionately. USCIS will likely no longer give deference to prior adjudications. What does that mean? I had an H-1B approved for myself. Now we're just filing an extension. Nothing's changed. Under the current administration, the fact that I already had an H-1B petition approved for the same facts gives deference to that prior approval. That may no longer be the case. We expect the wage levels to go up in the OFLC database. And we really expect the number of compliance audits to go up as well. We think H-1B petitions will be scrutinized more closely. And the way that will be done is perhaps by telling the adjudicators, you no longer have to adjudicate so many, X number of petitions in a week. It can be X minus 10, which means we're giving you more time to scrutinize the petitions on your desk, which will likely lead to higher denial rates. So we'd like for all of you to keep this in mind as you prepare your petitions going forward. And it might not be a bad idea to start thinking about what changes you need to make in your H-1B filings now, so you don't have to make hasty changes in 2025. And I would plan ahead for the 2025 CAP filings accordingly. Next. I think that's pretty much it from my end. It was nice speaking with all of you. If you have any questions, I think Khalif already mentioned how you could put them into the Q&A box, and we'll be happy to answer any questions you have.
Yeah, that was very comprehensive presentation. Thank you so much, Vinay. And we do have a lot of questions in our Q&A session already. And if anybody else have any questions, please feel free to post it on the Q&A, which is at the bottom of this webinar screen. So I'm going to read a few questions, and then you can answer those. One of the question is, there is an anonymous attendee. Can you explain a bit more on the electronic posting that is acceptable, and how does one do this?
Sure. So for the Department of Labor, an electronic posting is any posting that's not physical, right? So it could be an email, it could be an intranet posting, which is open only to the company. As long as such electronic media are used regularly in the course of business to communicate with all employees. So if we have an intranet where we regularly post notices or post any new policies, which is accessible to all US employees, instead of putting a physical posting of the LCA, you can post it on that media, right? But still, you still need to have the confirmation of the posting. It still needs to happen for 10 consecutive days, so on and so forth. So what I tell my clients is, if you place an electronic posting, say on an intranet, take a printout or a print screen with the date stamp, right? On day 1 and then day 10. And in the case of an audit, just make sure you can prove that all employees had access to that system. If you use emails for regular communications, take a printout of that email which says, hey, here's a copy of the LCA for an H-1B employee that was filed with the Department of Labor. And then on day 10, you can say, here's a copy again, today is a 10th day, right? So that's what we mean by electronic posting. Hopefully that answers your question.
There is another question by Prashant Veeraboma. He's saying, running OPT payroll, do we need to run based off of any project?
So this is a nuanced question. When you say OPT payroll, the question then becomes, it really depends. If it's a first year OPT, the requirements are very slim. You really you do not even have to pay. So there's one thing I'd like to clarify about OPT. There is no minimum LCA wage for OPTs, right? The OPT wage is the higher of the federal or the state minimum wage. That's the minimum wage you have to pay to an OPT. Now, when you say, does it have to be based off a project? So here is my answer. From what, again, there's a lot of details that would be needed to answer that question. But at a high level, if it's a year 1 OPT, please note that a person doesn't even have to be paid. It could be voluntary. If it's a STEM OPT, then it has to be paid, right? For that, you then have to look at the the form that was completed for STEM OPT. So STEM OPT has a training form that needs to be completed, right? So in there, you also have to indicate the location, meaning where is that STEM OPT employee going to work, right? So if it is tied to a project, right, you still have to pay that person again, because on STEM OPT, the person has to be paid, whether that project is, on or not, right? And the wage rate will be determined by where the person is working for that project. If the work location is Massachusetts, and if the state minimum wage of Massachusetts is $20 and the federal minimum wage is $15, you have to pay that OPT employee at least $20 an hour. Hopefully that answers your question, Prashant. If not, you can post a follow-up question.
Another question is, two questions actually. One is, if my specialty occupation is removed from the list, what happens to my H-1B? It's from Andrew.
Okay, so if your H-1B is already approved, you can keep working unless unless USCIS sends a notice of intent to revoke your H-1B. Highly unlikely. The problem will occur when you try to file for an extension under the same SOC code. And remember, I told you that it's likely that USCIS will no longer give deference to prior adjudications. So what they might say is, well, yes, we know 3 years ago we approved your H-1B for this particular specialty occupation. However, today that occupation is no longer on the list, so we cannot approve it.
Okay. Another question from Andre is, if I'm on a salary of $80,000 a year and it rises to 100,000, does my employer need to increase my salary now or only at the H-1B renewal?
The employer, it's really up to the employer. I mean, typically in the real world, if you get a raise, you get a raise. And, employers do not typically wait for the next H-1B extension to be filed to give you that raise. However, they can choose to do that as long as the employee is okay with it. And really, that's purely a business decision. Nothing in the H-1B regulations prohibit an employer from giving an H-1B employee a huge raise. I mean, in fact, that's what America is all about. If your worth goes up, you should get paid that wage. USCIS likes to see that. And on a related note, this is especially true in the Trump administration, because I remember, from 4 years ago, every time you filed an extension, USCIS would not be very happy if the H-1B salary filed in an extension is exactly the same as it was from 3 years ago, right? Because in the real world, we at least get a cost of living increase every year. So if you do not file an extension with at least a minor increase in salary, that might raise some red flags in the extension petition.
Another question from an anonymous attendee is, folks here try to get alternate jobs. So they want us to hold till they find something. 60 days period, return offer to home, to their country. They do not want to go back while looking for another job. We cannot keep track of their job searches.
So from an employer perspective, right, what we tell our employees is our clients is, look, here's the rule. The rule is, unless you follow these 3 steps, you're on the hook to pay wages. So it's really a business decision, right? Where you say, look, I really appreciate the fact that you do not want to go back. You have 60 days, so on and so forth. If as an employer, in my opinion, you do not have the resources to pay the employee, you're better off terminating them. They still have 60 days, right? As long as the I-94 is not expired, to find another job and transfer to the new employer. At least you're not on the hook for those 60 days, right? For the salary, because DOL is very, very tough on employers when it comes to not paying salaries. I mean, that's one thing the DOL is very, very strict about. And the penalties for not paying the salaries are very, very severe. So I would ask you to consider this before you decide to, maybe out of the goodness of your heart, keep an employee on payroll but not pay them and trying to, help them out, find another job because this might come to bite you later on.
Another question is, does the LCA posting have to be at the end client location, or would the employer's physical office be sufficient?
If on the LCA, the work location is the end client's location, the LCA has to be posted at that location.
Okay. Another question is, we have an H-1B employee coming from India. After how many days after coming here, the employee has to be on the payroll?
30 days. So the rules, the DOL rules say if it's a person entering on H-1B status, they have to present themselves to your office for employment within 30 days of their entry into the US. On the other hand, if it's a change of status approval, meaning someone was an H1 or H4, OPT, F1, or H4, or what have you, they have 60 days from the date of approval to start getting paid of
Okay.
their H-1B wage.
Okay. Just letting all the attendees know that write all your questions in the Q&A box at the bottom of your screen. We will be taking those questions here. Another question here is, what are the implications for H-1B transfer petition when one is changing their roles to a different domain? Is it even possible?
It is possible. Anything is possible in life. I mean, even in the H-1B context, let's just give you an example. I'm a software developer. My current H-1B is under the SOC code of a software developer. I started going to school at night to become a network engineer, and I got my Cisco certification or Juniper certification, and I feel I'm ready to work as a network engineer, and my software development background gives me a leap up. My next job could be, excuse me, as a computer network architect, which is a different SOC code. There's nothing wrong with that, right? As long as my degree and experience is consistent with the requirements of that position.
Okay. It's another anonymous attendee question. It says certified LCA, or can we have initiated LCA in their PAF? I don't know what that question means.
Right. I think I understand. So when you create the public access file, you have to create it within 1 day of filing the LCA. So by definition, you'll put the initiated LCA in the public access file because your LCA would not have been certified by then, right? In fact, I'd love it if it gets certified within a day. It's not going to happen. Typically, LCAs get certified in 5 to 7 business days. So you create the public access file, you place the initiated LCA in it. 7 days later, the LCA gets certified. You replace the initiated LCA with the certified LCA in the same file.
Another question is, I was with a big company and laid off recently. I'm being paid bi-weekly payroll, like severance period. When does my grace period will start?
The grace period under USCIS policy will start on the last day you were paid.
Okay. Another question, what happens if the employee take extended leave even before occurring vacation time? Does employer need to pay for the extended leave or unapproved leaves?
So under DOL rules, if an employee wants to take extended leave, ideally the way it works is they first take the paid time off, right? Once that is over, they need to then let the employer know in writing that, hey, you know, I am, for example, pregnant, I need maternity leave, my health does not permit me to work, please approve unpaid leave. Or my parents or in-laws have come to the US, I want to take them on a 2-month tour of the United States. I've used up all my paid time off, please place me on unpaid leave. The employer then needs to approve such a request in writing and keep that with them right? In that case, that employee can continue to be on H-1B status. Then that's not benching, right? Because it's not the employer saying, I do not want to pay you. It's the employee saying that they cannot work for, an acceptable reason. Does that answer the question?
Yeah, I think so. Another question is, my previous H-1B petition, valid from 2020 to 2023, was revoked in February 2023. I left my former organization in April 2022. However, I had already received an approved petition, which is valid from April 2022 to March 2025, from my new employer before leaving the old company. And I also have a stamped visa from the new company. I'm now going for an extension. Could you please tell me, will there be any issues because my previous petition was revoked?
It depends on what grounds was the previous petition revoked. If it was revoked on grounds of fraud or misrepresentation, and if USCIS thinks that you, the H-1B employee, were part of that fraud or misrepresentation, it could affect your H-1B extension, your stamping abroad. So I would ask you to get more details about the circumstances pertaining to the revocation. Now, if you find out, and again, this is lots of ifs and buts, you find out that it was revoked due to fraud or misrepresentation, and if USCIS in its records has you tainted as one of the persons part of the fraud or misrepresentation, you really should find a competent immigration attorney to file a lawsuit in the US to try and get that fraud finding against you removed so you have no problems when you go to get a stamp at the US Embassy.
Okay, another question is there a verbiage to use offer return transportation that you can share?
Well, I can say that right now. Should you desire to return to your home country of whatever it is, we will offer you one-way economy class ticket, and that's pretty much it. And then you leave it for the employee to come back to you and say, yes, I'm going back. Please give me the money for the ticket. So
Okay.
again, you have to offer. The offer does not have to be accepted.
Mm-hmm. Okay. Another question is, can an employee know his H-1B revoked or not?
If you have a copy, if you have the receipt number of your H-1B approval, you can go to uscis.gov and enter the receipt number and see what happens. All it will tell you is that whether it was revoked or not. Again, the circumstances of the revocation will not be something that will be shown online. You need a copy of the revocation notice, which your employer, uh, should have.
Okay. Another question is, my current visa stamp is valid until September 25th, and I have a new I-797 approval notice. Could you please clarify if a new visa stamp is required to align with the latest approval? Is my existing visa stamp is sufficient until September? I had a travel in Jan 2025.
Well, so the visa stamp is like an entry ticket into the US. If it's valid until September 2025, you can use the same stamp to re-enter the US until whatever the expiration date of the visa stamp is. It does not have to be tied to your current employer. I would just make sure that I take the latest approval notice with me, when I'm coming back in, so I can get my I-94 extended until the expiration date of my latest approval notice. However, should I choose to re-enter the US after the expiration of the current H-1B stamp, absent automatic revalidation, and that's a whole separate topic, yes, I would have to get a visa stamp. Now, again, if a little bit of segue into automatic revalidation, some of you may be aware if you're traveling to countries that have land borders with the US, like Canada or Mexico. And if you're traveling for less than 30 days, you can come back even on an expired visa stamp as long as your I-94 is still valid. right, with your I-797 approval notice.
Okay. Another question is, are there any travel restrictions when one has filing an H-1B transfer petition?
I always counsel my clients to not travel when you have a transfer petition pending, uh, especially if you have quit your previous employer and are working for the new employer, and that case hasn't been approved as yet. It could lead, it depends on who you draw at the CBP. Some officers are not well trained and they might say, oh, you don't have an approval notice because you're working with this employer. They may not quite understand how H-1B portability works. So I would say, unless you're still working for the previously approved employer, do not travel until you get an approval for your transfer.
Okay. Another question is, do we have to pay for dependents too? I'm assuming maybe going back.
No, no. So I'm an H-1B employee. I have one wife. You can only have one wife in the US and 10 kids. You only have to pay for my return to my home country, not my wife and the 10 kids.
Okay. Another question is, could you repeat 30-day rule of traveling back when visa is expired, but I-797 is valid date?
Sure. So under the automatic visa revalidation program, if you're on an H-1B and there are some other visa categories as well, you can travel to countries that are contiguous to the United States for short trips, not exceeding 30 days, and come back into the US, even if you have an expired visa stamp, as long as your I-94 is unexpired.
Okay. Another question is, my current H-1B visa is active till January 2025. I have a new I-797 approved till Jan 8, 2028. Can travel and return back to US on Jan 2nd to 3rd, 2025 without any renewing my
What
visa.
is the expiration of the visa stamp again?
So there is an H-1B active till Jan 8, 2025.
When you say H-1B, I'm sorry, Kalika, I shouldn't put you on the spot. If the H-1B visa is valid until Jan 8th, 2025, you can re-enter the country using that visa until Jan 8th, 2025.
And he said he or she also have a new I-797 approved till Jan 8, 2028.
So what they should do is when they re-enter the country prior to the expiration of the US visa stamp, they should have a copy of the I-797 approval notice with the 2028 expiration date and present that to the CBP officer so that when the CBP officer processes them, he or she extends their I-94 to the 2028 date. And on a side note, it's very important because we no longer have stamped I-94s on our passports, that when you enter the country, you should check your I-94 status on the CBP website and make sure it is consistent with the latest H-1B approval you have. Because CBP officers can sometimes make mistakes and you only have a short window to get that fixed. Otherwise, you have to leave the country and re-enter.
Okay. Another question is, when I reached out to my employer to request the revocation letter, I received the response that withdrawal notices are employer related and that it is not required for me. Is this correct? Should
It
I
is correct.
not
I'm
have
sorry.
the right to receive the reason or a copy of the letter?
Um, the employer doesn't have to give it to you, but you can file a freedom of information request. It's called a FOIA request with USCIS and get it that way.
Another question is there any specific deadline to run paycheck for new H-1B employee? Can employer run paycheck bi-monthly for employee?
So, I mean, that it's just a frequency, right? If that's the question, yeah, you can run it. When you say bi-monthly, it's once every 2 months. That's a little suspect. The reason being DOL likes to see people paid every month at least. So no later than a month. You can do it bi-weekly, you can do it weekly, you can do it monthly, but bi-monthly starts getting a little tricky. I wouldn't advise that.
Okay. Another question, as an employer, how do we manage the H-1B status of an employee when they lose their project and remain on the bench for a couple of months?
If you cannot pay them, you need to let them go. Or if they can say that, if they can prove that they want to take unpaid leave, as I just said, then they go on unpaid leave as long as it's documented.
Okay. Those are all the questions for today. Oh, one more popped up. What happens if an employee travels out of the country for 2, 3 months, unpaid leave, and re-enter US? Any specific document employer need to provide employee for smooth entry back to the US?
As I said, you need to document the request for unpaid leave from the employee, the reasons for such requests, backed by corroborating evidence, for example, a doctor's note or something like that. And that request has to be approved, and I would take all that documentation with me. And you use that to come back into the US.
Okay. Another question is, how long can be that unpaid leave while on bench?
Commensurate with the circumstances, right? So I don't think USCIS would buy an excuse as, hey, I wanted to take a year off to tour the United States, right? So if you're going to tour the United States, maybe 2 months max. I took a camping trip or something. If it's an accident, then again, it depends on the nature of the accident, right? So it's very specific to the facts and circumstances of each case.
Okay. So I also actually have a question. So do you think an employee have to be paid if they cannot work due to personal reasons?
Again, if they cannot work due to personal reasons, they should first they should use up their paid time off. And then two, they need to document the reason why they cannot work due to their personal reasons. So they have to say, I have an ailing parent and I need to be their full-time caregiver for at least the next few months, right? So that needs to be documented. The parent's medical situation needs to be documented, and then that leave needs to be approved, and then you're good to go.
Okay.
I have a question too, and this is Kat. So, where should be the public access file be stored?
So, good question. The public access file can be stored in a physical copy, right? Typically with the HR department, or it could be, in an electronic repository as well. It just needs to be accessible or made accessible to any member of the public should there be a request for that. So, doesn't have to be a physical copy. It could be electronic. It needs to be, under the control of someone in the petitioner's office, typically the HR department, and it should be accessible so that if needed, it can be downloaded or printed out.
Okay. Another question we have is, are we expecting any difference on how USCIS handles H-1B with new administration?
Absolutely, undoubtedly. Um, First of all, just from a political perspective, immigration was a key campaigning plank for the Trump administration. This administration won in a landslide. They won the popular vote. Uh, the federal agencies are under the direct power of the executive, which is the White House, which is the president. So they have a lot of power over the federal agencies. So yes, there will be very, very significant changes to the U.S. immigration program in the next few months.
Okay. Another question is, my spouse has H-4EAD and she owns a ID consulting company. Can I transfer my H-1B to that company? This is a C Corp.
If you do not have an ownership interest in that company, then probably yes. We'd have to look at the specifics. But I mean, if you look at it disjunctively, your wife has every right to own a company on EAD. You can own a company on EAD. Can you work for another company? Sure, you can transfer as long as it's an H-1B specialty occupation position and the duties are, consistent with the occupation. The only caveat is you cannot have an ownership interest in that company because then you're no longer an employee of that company because there needs to be an employer-employee relationship.
Okay. Well, I think these are all the questions. Well, thank you so much, Vinay, for your time. And if anybody have any more questions, please feel free to email us at info@vkmlawgroup.com. We can answer any of your questions, any requests that you have. Um, well, thank you so much, everyone, for your time. We really appreciate it. And VKM Law Group is here to support you with any further questions you have. Like I said, you can feel free to reach out to us. Our email address is info@vkmlawgroup.com. Thank you again, and we look forward to connecting with you soon.
And just so you know, we have a very robust team here to take care of all of your compliance needs. So we look forward to hearing from you.
All right. Thanks, everyone.